was largely focused on standing in terms of just looking at the transcript and looking at the pleadings before. I'll keep an open mind, but it looks like the standing issue is kind of satisfied now because these are members of the organization. That's just my first blush at it. And so then we get more into like the substantive area. And I guess my question is, have there been any conversations now between you, Mr. Snyder, and you, Mr. Lohr, related to whether or not there's a resolution here? Mr. Snyder?
There have not, Your Honor. There were significant discussions with between me and both of the society's prior attorneys. The detailed proposal for the election process that is at the end of my brief was the result of one set of those discussions. But since, I'm forgetting the prior attorney's last name. I'm remembering Joe. But since the most recent attorney withdrew, I have not had any contact with the society.
Because underlying, all of these things, I think there's pride, and I think there's, it's personal as well, or at least a component of it. But then we're also looking at the procedure. And so, Mr. Lohr, did you see what Mr. Snyder is asking for at the end of their motion? Did you see that and read that?
Your Honor, first, I just want to clear that I am not here as an attorney or represent. If I may speak, I would just designate it as the individual to join Zoom today. Yes, sir. We have looked at the request or the briefing from our prior attorney. I was brief. The board was actually brief on that, and we felt that again, we as the organization, serve the community, and that that's something that we have done to the best of our ability, that we just can't have any funds in the account to continue this litigation. But we did, at one point I was aware that there was supposed to be a mediation that perhaps the two can have a dialogue and about this election. I mean, we're about 8 months away for a new term in office, and we felt that if the plaintiff could wait until then they can send in their candidate to run for office. I mean, the board of directors are no longer interested in running this office, but we will hold onto the term until 8 months from now. Or perhaps if the plaintiff wanted to have early election, at least they would convey that message to us, and we are more than happy to accommodate their request.
It seemed like, Mr. Snyder, the two issues from reading the documents, one issue relates to whether or not the other officers are elected besides the president. And when I look at, and so that's one issue, and then the other one, so there was one issue related to whether they're elected or appointed, and then the other issue was whether it's a 3-year or a 4-year term. Am I wrong?
Those are certainly specific provisions that are an issue. Our key concern really is that the board has not been elected.
But isn't it optional under the articles? It says that the president is elected, but then it says that the rest of the officers may. Like under the original articles of incorporation, it says may. To me, that means that you get to make a choice, and choice, they've decided not.
Your Honor, I'm looking at Article 5 from the original articles, and it says the board members of this corporation shall be elected by a simple majority.
Pull it up here. So, are we talking about the 1994 article?
Correct, Your Honor. Article 5.
Yeah, and it says, the president shall be elected by the membership, while the election of the vice president, treasurer, and secretary may be optional.
Oh, okay. Yes, Your Honor.
And that final clause seems to indicate that the shall modifies the president, and that as it relates to the other officers, that's optional, and if it's optional, then they're not required to have them elected.
I agree with you up to a point, Your Honor.
Okay.
The distinction that the mistake I think you're making is that you are lumping officers in with board of directors. So, the board of directors, and they are, if you read that final clause, the final sentence, the term of office for the above officers, comma, the board of directors, and the state chapters shall be a 3-year term. Officers and board are not the same thing.
Got it.
So the officers other than president are optional. And in fact, in the proposal I've made, I just looked at it now, and now I'm forgetting I think I left that to be those positions to be appointed, in fact. And that's common with nonprofits that do have these sorts of elections.
And so the rub is that under the 1994 Articles of Incorporation, the board members need to be elected, and under the later iterations, the bylaws that were passed later in 2019 and so on, that the president sought out people to be on the board and volunteer their time, and then they were just on the board. Is that the problem?
I believe that is effective. That is the problem, Your Honor, and I believe that is essentially what happened. The bylaws were changed, and then ultimately, without approval of the membership, the articles were changed to allow only election of the president, who appoints an executive committee who then picks the board. So it rested all of the authority in one person. And if an organization wants to be set up that way, in and of itself, that's not illegal. But this organization is not set up that way.
So I'm going to have Mr. Snyder and Mr. Lohr, I'm going to put you in a breakout room so you can just have a conversation with one another about what you think the next steps are. I've got two choices as a judge. I got a motion in front of me. I think that I got three paths. One, I can just decide the motion. Yeah, and I can just do that, right? And even though there wasn't a response to that motion, it's a matter of law and interpretation, and I can just look at it and make a call. The second thing that I can do is I theoretically can force people to go to mediation with a formal mediator. So that's like the second path. And then the third, I can just kind of continue this matter down the road a little bit to give the National Lopha Society an opportunity to hire an attorney, or to talk a little bit more about whether or not they want to hire an attorney, or have some more conversations informally without an attorney with Mr. Snyder. Those are the three paths that I see. And as a judge, and Mr. Snyder probably agree with this, it's always better for the parties to reach an agreement as opposed to having a judge push their decision onto the parties for a variety of reasons. One of which is that if I make the decision on my own, y'all can appeal it, and then now you get another year or 2 years of litigation and expenses and stress and ambiguity and things like that, which nobody wants, right? But that's what happens when a judge makes a decision, and they should. People have the right to appeal, and God bless them, they can do it. And then the Court of Appeals will tell me whether I was right or wrong, and we can go from there. But it seems like for everybody, it's always better to kind of just be an adult and come together and figure it out. And so I want to give some space to that, because what I'm hearing from you, Mr. Lohr, is that you're tired. Yeah, and you want this done.
Yes, sir.
And so maybe if you guys want to chat a little bit, you can, without me present. That might make some sense. So I'm going to call a timeout, and I'm going to ask David to put Mr. Snyder and Mr. Lohr in a room together so that they can just talk with one another, and then we'll go from there. Is that okay by you, Mr. Snyder?
Yes, that's fine, Your Honor. Since it is a settlement discussion, I would ask that the recording be paused. I've noted that the breakout rooms continue to be recorded.
Okay. That's beyond my
Recording
technical
stopped.
ability, but it'll be turned off if we can do it.
I just heard that it was done, so
Okay, all right. Sounds good.
thank you, Your Honor.
Thank you.
Can you make sure my phone's not too loud? Good morning, attorney.
Good morning, Mr. Lohr.
Sorry,
It's fine.
I apologize. Our attorney is no longer here, and I'm not an attorney, but I am more than happy. Whatever you want us to do, we will do our best to accommodate that.
Okay. Well, and as I told the judge, my firm represents nonprofit organizations.
Yes,
I
sir.
understand sometimes money is limited. So,
Yes.
and your lawyers have been telling me that you guys don't have a ton of money, and given the type of organization you are, that doesn't surprise me.
Yes, sir.
So I have at the end of the brief that I submitted a pretty detailed
Right.
plan to hold an election.
Yes.
And the idea there was that came from, and wow, my memory's just killing me today. Your first Mr. Ledeen.
Yes.
He and I had negotiated that, and we got pretty close to an agreement there. And I don't remember where it broke down, but it did. But when I wrote that, I used what we had negotiated, one, because it felt fair, because it was something you guys had been in on. And I think it makes sense. And I made it, the last time we had an argument, I don't know if you were there, the judge commented on how detailed it was, but
Sure.
I made it that detailed because, you and my clients have been in disagreement, and we might as well get all the rules set out now.
Yes.
So there's not much to argue over later.
Yes,
Is
sir.
my hope.
Yes.
Because I think you all want this organization to succeed.
Correct.
So I would like you all to have an organization that succeeds.
Yes.
So that's why I spelled it out. So I've got a detailed proposal there. And I don't know when the last time was that you read through it. But if you're willing to follow that proposal and get an election scheduled, so what we would be doing is having an election for a board and president, and then I think, as I told the judge, I believe what I proposed was that the treasurer and vice president and secretary would be appointed, and that your articles allow for that, and that simplifies it. It's one less vote to have. And I didn't put a timeline in the papers, in the draft order I just submitted to the court this morning. I proposed that the meeting be held within 90 days. And it could be remote.
Okay.
If that makes the most sense for y'all, because I know you're spread out all over the country.
Yes.
So, yeah, I would like you, and then my thought is elect a new board, and that board can go, if you all decide, it doesn't make sense to have elections the way our articles originally said. So let's change it. Go through the process of the formal legal process of changing things. Maybe that'll make sense, and an attorney could help you do that if you have the funds to do that.
Yes, sir.
And then move forward with the organization. I'm sure COVID didn't help your organization any.
No.
So I guess what I'm asking in a long-winded lawyerly way is, are you okay with the proposal that is in the brief that I filed with the court?
I don't recall if I seen the proposal, but
It's the last few pages of the brief.
okay.
And you should have received by email today something that I just filed with the court.
Okay.
And that has the full detailed proposal.
Okay. And good. Well,
And I can walk you through it here quickly.
sure. Could you? Yes.
All right, hold on. It's here somewhere. Here it is. So within 90 days, schedule a meeting to hold the election.
Okay.
Provide notice to members.
Okay.
Permit all members over the age of 18 to vote. That is subject to Minnesota law.
Okay.
That people have to be on a list of members. People who are the registered members, that's easy.
Okay.
But others would have to be on a membership list, and I've got some details on how to address that. But
Okay.
Minnesota law requires that list to be figured out 30 days before the election.
Sure.
So people can't just show up on the day of the
Okay.
meeting and say, I want to vote.
Okay. Got it.
Promptly secure a location to hold the election. If necessary, it can be held by remotely, so by Zoom. And what I put in here was because of bad weather or other issues. I think my clients are open to the idea of just doing it over Zoom. If you think that would be a better idea, if that would work better. It's a little, depending on how many people come, holding an election on Zoom is a little bit of a nightmare. But maybe we could work something out. On the membership list that, I'm assuming the society has a membership list. I know you've got the registered members, but I assume you've got other information on who your members are.
Yes.
So that within 7 days, you would share we would exchange membership lists, because my clients have what they think the membership list should look like, and then we would combine those into one list. That's the list. We'd send notice to people on that list of the meeting, and those are the people who get to vote.
Okay.
And if they come, they vote, they do, and if they don't, they don't. So then it's got that the notice will have the date, time, location of the meeting. That's all required by Minnesota statutes, so it's just following the statutes. Everybody who attends the meeting will register, so they'll sign in some way so that we know they're on the list.
Okay.
If their name isn't on the list, they're not allowed to vote. Elect a 13-member board of directors. Do that vote first. Nominations can be taken from the floor. Self-nominations are permitted. Each nominee can have up to 3 minutes to speak. I think that you may have had that in one of your bylaws.
Yes.
With that many people, keeping it short is a good idea.
Okay.
Everybody gets to vote for the 13 candidates. The way I proposed it was everybody who votes just lists their top 13 candidates. So if you have 15 people who want to be on the board, which you may not have, I'm on a lot of boards that we can never fill up, so you never know. But everybody votes once by writing down 13 people. Whoever gets the 13 people who get the most votes become instead of holding 13 different elections for
Sure.
13 different
Sure.
so I just thought it was simpler, and so did Steve, your prior lawyer. And then after the board of directors is elected, then one of those 13 people will be elected president. Everybody who's there gets to vote on who the president is. Then meeting will be managed by an election committee comprised of 3 people, my client's name, and 3 people, you or the board name, to greet and register members, explain the process, manage the nomination process to make sure everybody keeps to that 3 minutes and things like that, collect the ballots, tabulate the votes, and if issues come up, they'll be the ones to figure them out.
Okay, sure.
The newly elected board will elect its own other officers, is what I said. So vice president, treasurer, and secretary, so the board would pick.
Okay.
And then everybody will cooperate to get records and information and all of that transferred.
Sure.
And that's pretty much the whole proposal.
Okay. Very good, attorney. I think we're very simple at this point. I would recommend that the plaintiff hire you to draft a new proposal in place, the article and the bylaws complete the way that they want it. Let's see. Prior
Just
to.
calling back here.
Oh, okay. Can you hear me?
Sorry.
Yeah.
Yep.
I think it's the best interest for both parties to have an attorney like you to have the articles and the bylaw drafted the way they would want to see. And that in place prior to any election. And I'm thinking that the board of directors and the other members has approved that we are no longer willing to seek another term. So therefore, I believe that if the articles and the bylaws are drafted properly, to continue the organization in a good standing manner, then I think that the community will be very happy. I don't think that we need to hold an election. We may very well turn the organization to this people, the plaintiff, as of January 1st.
Recording in progress.
All right, so we have Mr. Moore back and Mr. Snyder's back, and chances are we interrupted some fruitful discussions. I apologize for that.
Zoom does give notice, so it wasn't a surprise.
Okay. So we'll just start with you, Mr. Snyder, then I'll hear from you, Mr. Lohr. What are your thoughts in terms of the next steps? You can do your perspective, or if there is an agreement, that's fine too.
I don't think we reached the point of agreement. Mr. Lohr had not, at least recently, gone through the specific proposal I made in the briefing, so we talked through that. I don't think and I don't want to speak for him, so Mr. Lohr, let me know if I'm misrepresenting anything here, but my sense was he was nodding along as I talked through it and was okay with the general concept. As we were wrapping up and we came back into court, what he was saying is, in his view, the current board isn't going to be around, wants to step down anyway. He's got a procedurally different idea for having, for what he proposed was that I would draft new bylaws, new amendment, new articles that would be, we didn't get to the point of exactly what would be done with those, and procedurally, and there's no reason for Mr. Lohr to know this, but I think from a legal perspective, there's not really anything I'm happy to draft them and have them available for people to look at, but there's nothing, we're at the point of having an underlying dispute about who even can vote on those, which is why we need to have the election. So I don't know what to do with them. And we sort of got cut off in the midst of that conversation, so Mr. Lohr is hearing that from me for the first time.
So, Mr. Lohr, what are your thoughts in terms of just procedurally? Next step, you don't have to tell me, your discussions; those are settlement discussions. But just in terms of what you want me to do today, you're on mute.
Your Honor, I thank you for allowing me to say a few words. If you would grant us 10 days, maybe perhaps the board of directors can have conversation with Mr. Snyder, the attorney. I think that at this point, the best interest for both parties is that we need to come to a good conclusion how to make this organization run smooth and effective in the future. The current administrations are no longer interested in running the organization. Again, we understand that the plaintiff wanted a 90 days election. I think that's possible, that we can have that conversation. We just want an attorney to come in and help both parties to have the articles and bylaws drafted so that we don't have this issue again. And that will be something that I believe that the plaintiff brought up the issue where they need to cover the costs to make sure that all of this is in place prior to the current board to step down. And we are willing to do that once this is in place. And if that is possible, I think that would be good for both parties. And I believe that the board would like that to be happened.
And if I'm not mistaken, maybe I'm wrong. You can fill me in, but I mean, it doesn't seem like there's some real ongoing big programmatic thing that like is happening on a day-to-day basis that the society has to run, in which there's big conflict related to the operation of an after-school program or something like that. From my reading, it looked like that there's like the big meeting that happens once a year.
Yes.
That's kind of a combination of cultural and family reunion. But beyond that, there's not a lot of activity. That most of the activity relates to planning that big meeting and that big coming together, and that there's not a lot of programming in between those, for lack of a better word, the tentpoles of one meeting from one year to the next. There's kind of a lull and then it ramps up. Am I wrong in that, Mr. Lohr?
You're correct, sir.
And then the next meeting is, you said, 8 months from now?
Yes, sir. May of 23. Yes, sir.
Yeah. And so, I mean, just by way of perspective, if I was to take something under advisement, theoretically, I have 3 months to rule. So that gets us to 5, right? And then if I ruled in Mr. Snyder's favor and ordered an election to be 90 days from the date that I ruled, that would get us to 6. And so then we're talking about 60 days. That seems like a lot of work.
Yes.
If there's an agreement to just either to do it, I mean, you can do whatever you want, but I was just trying to figure out sort of the timing of things, and maybe it's not a big deal to just hold an election in 90 days. Maybe it is. I have no idea. But that's the other sort of thing to consider.
Yes, sir.
So, Mr. Snyder, I think I'm gonna just continue this, for a couple weeks, to give you an opportunity to just talk to Mr. Lohr and see if you can figure something out. And then if there's not an agreement or if there's something in particular, then I'll just make my decision at that I'll hear the arguments, make my decision at the next hearing and go from there. But hopefully, an agreement can be made.
It's certainly not beyond the realm of possibility, or I would push back on that proposal. I'm wondering, for the sake of efficiency, if the court has questions about any of the arguments, certainly I'm willing to address them, but since I don't have an opposition to respond to, really, I don't have anything necessarily to add to what's in the papers.
No, they're pretty self-explanatory when I read it, because I looked at both the original pleadings and then I looked at what I got before me today. So I think you corrected me in sort of my reading of that original article. So that was sort of one of the big ones. So I don't really have any.
So we may want to consider just, if we're not able to reach an agreement, just submitting it on the papers and picking a date that it goes under advisement for the purposes of the 90 days. I'm perfectly willing to come back and argue, but I would mostly be telling you what you've already read. And I am glad I had the opportunity to clarify that one issue.
Yeah. So why don't we? So today is the 30th. And so we'll just say if there's not an agreement reached by September 30th, then you can submit a letter to me letting me know, and at that point I'll take it under advisement and make a decision from there. That's critical. So September 30th will be the time for submissions, and obviously, Mr. Lohr, if you want to hire an attorney
Yes, sir.
to submit something, that would be fine. And then Mr. Snyder, obviously, I think needs to have an ability to reply to that within a specific period of time. I'm not anticipating that, but I think it's just only fair. So, all right. So hopefully y'all can continue to talk, and hopefully a resolution can be reached. I think that one can, and then everything can kind of settle down and hopefully get back to what the society's intention is, and that is to celebrate one another in those relationships going forward. So we'll go from there. Mr. Snyder, anything further?
Nothing further, Your Honor.
Mr. Lohr, anything further from you, sir?
No, sir. Thank you.
All right. I appreciate it, everybody. Thank you.
Thank you, Your Honor.